Hello, my name's Brian Hudson, and this is another self-help video. This time, the topic is preparing statements and exhibits for family court. So in this session, we are going to cover the general principles that you should be applying when you're preparing your statements. Um, I'll be showing you what your cover pages should look like, both for your statement and for your exhibit. I'll just run you quickly through the statement of truth that you need to include in your statement. I'll be walking you through how to structure your exhibit and how you should provide an index and then bundle your documents together into one single document that's easy to navigate. Once you're into your statement, I'll just describe what you need to be including, types of things you need to include in the background information within your statement, how you should respond to allegations that have been made against you, whether and how you should make any counter allegations that are relevant, putting forward solutions, and asking for the outcome that you're seeking. So, general principles that you ought to follow. This is your opportunity to bring clarity to the judge and to any professionals that are brought in to assist with the hearing and navigating to an outcome. So it's going to be the single most important document and representation of you and what the truth is from your perspective. Judges have a very short span of attention. Their job is 5 days a week to listen to couples arguing over various topics, whether true or false, and that can be something that leads to them switching off very easily if there is too much noise and irrelevance and confusion. So you need to bear that in mind, stay concise, stay relevant, and avoid waffle. In your statement, you need to be citing evidence for any claim that you're making. If you don't have evidence, you really consider carefully whether you want to raise that allegation at all. In responding to any allegations that have been made against you, you should be citing any lack of evidence that the accusing party hasn't included to back up the claim that they're making. And if you have evidence that contradicts a claim that they are making against you, then you'll need to provide that in your exhibit and cite it in your statement. I think it's best to avoid counter allegations unless they are specifically relevant and you have compelling evidence to back them up. Otherwise, you risk, just confusing matters even more. And you need to make sure that your statement is easy to read. So, that would mean reading through it over and over and over, working on the language that you're using, making sure that you aren't making errors and that it makes sense, relying perhaps on a trusted third party to review it for you, comment on it, help you edit it. And it needs to be easy to navigate and it needs to demonstrate any claim that you are making, and that needs to be really clear. You have to be able to demonstrate that it's the truth, not just make a statement, make a claim, and not back that up. Moving on to cover pages. So the cover page for your exhibit will need to look just like this, and there's a template that you can find on my website. So I'll give the address at the end of this slideshow. So at the top here, you want to put in the court name that your hearing is being heard at. Populate in here the case number that's been assigned. And then you need to put in the name of the child or the children, whether they're a girl or a boy, and their dates of birth where applicable. And then you put in the name of the applicant, so that could be you or it could be the other side. And you put in the name of the respondent, and again, that could be you or the other side. And then you would put in here what the document is. So in this example, it's an index to your exhibit, and you're of course saying, so for example, in this case, this exhibit BH1, that's the reference that as an example that I'd give to this exhibit, and it's an exhibit to the first statement that's being made and who the person is that's statement and exhibit belong to. Okay. Exhibit also needs an index. So um, having just scrolled down from the cover page that I just showed you, this would show the documents that you've got contained in your index. So rather than creating a bunch of exhibits and giving each exhibit a separate exhibit reference, so for example, BH1, BH2, and so on, you would enter each document into this table, date it, and then paginate, i.e. you're telling whoever's using this index where they'll be able to find that particular documentation. Moving to the statement cover page, it's exactly the same as the index cover page. The only difference being that you are changing the title in between these two lines here. So, for example, this is the first statement of Josephine Blogs, and you're adding the date on here as to when you are publishing that statement. Moving on to your intro and the statement of truth. You need to tell the court who you are. Okay, so insert your full name in here, insert your address, and then tell them how old you are in years, and that you are the father or the mother of a particular child by putting their name in there, put their age also, and then insert the name of the other party, who might be the applicant or the respondent or the mother or father, whoever you are against in these proceedings. Insert their age and tell the court whether they're the mother or the father. And then, as a pretty standard paragraph, you want to put in a statement of truth. So I'm not going to read that. You can find this statement of truth in the template on my website, and I'll give you the address at the end of the slide deck. So going back to the structure of the exhibit, this is really important. So what I'm saying is, rather than giving each piece of evidence that you put into your exhibit an exhibit reference itself, so if you have some photographs, instead of calling that BH1 and then there's some emails calling it BH2, and then a receipt calling it BH3, you just want to stick with one exhibit name. So BH1, for example, and give each document within a name and refer to the page ranges when you are citing that document in your statement. So moving on to indexing and bundling the exhibit documents. First thing to remember is you can make things a lot easier for yourself by saving each document that's going into your exhibit using a file naming convention that's common. Okay, so what I suggest that you do is start the file name with the year, and then the month, and then the day. Okay, and then a dash, and then the name of your file. Okay, so email between mother and father, for example. So in this example here, it's 2024, 01 being January and the 30th. Okay, so you're doing that in reverse order. And the reason for doing that is that it will save you a lot of time. So it will save the file in date order in Windows, and that will help you prevent errors and time being wasted later on. So what that looks like in practice is here you can see you've got the file name in each case where I've put the date in year, month, and then day. And in some cases you might also put time if you are exhibiting email correspondence, for example, and there are lots of back and forth on a particular day, you might need to do that, as in this example. But generally, you just need the date, and then that will sort into date order for you and make things easier later on when it comes to bundling up those documents. So the next thing, when you start writing your statement, is you start off by giving the judge some background. So in here, you want to, spend perhaps a page, around about a page, with a little bit of background information as to what led you to be in the hearing that's before them. So that could include some commentary on events such as the applicant and I met in January 2015 at a dinner and dance. We dated for a year and we were married on the 14th of February 2016. Our first child, called Scott, was born on the 15th of August 2017. So that would be, an example. And then you might go on to say, we had some great times in our relationship, but things became difficult when a particular life event hit us. So that's the kind of theme that you're looking to just give the judge and any other professionals that might end up reading this statement a bit of background as to what you're in the court for. Um, I find that one page is usually ample, but obviously that's going to vary depending on the nature of your case and the complexity. And that's a decision for you, but do try to keep it concise and do keep it relevant. So many of the people that I work with are usually responding to allegations that have been made against them. So there's kind of a format that I um, guide my clients to follow. Um, so um, each paragraph in their statement or in your statement needs to be numbered. Um, the other side in the proceedings, likewise, they will need to be numbering each of their paragraphs in their statement. And the idea of that is to assist navigating documents when you're citing parts of a document or specific documents. So you can refer to paragraph numbers and page numbers and document references. And it makes that much easier then when professionals, including the judge, are trying to navigate what you're telling them in your statement and find the relevant evidence that backs up what you're saying. In my experience, responding thoroughly to allegations that have been made against you will probably take up at least half of your statement. It's going to be from half to, 2/3 or more of your statement, going through methodically the claims that have been made against you and forensically breaking those down to take away the confusion and to provide evidence that gives your side of the story. Um, it really helps to be methodical rather than emotional. And that's easier said than done because when you're being accused of things that you may not have done, you can feel a significant sense of betrayal and emotional upset, and that can cloud the way that you communicate back and lead to you um, retaliating or sounding like you want to retaliate or punish the other party. So try to detach yourself from that and just be methodical, one at a time, break down each allegation, find your evidence that supports your side of the story, and then just methodically lay that out in simple terms that's easy to follow without any unnecessary waffle accompanying it. Put a section heading before starting each new part of your statement. So, for example, um, once you've written your background out, your next heading might be responses to the applicant's allegations, and then you would start at the next paragraph number. So, begin each new response paragraph with the words in response to allegations made in paragraph X of the applicant's statement and bold the citation, paragraph, location. So the judge knows that you're referring to something that they need to go and verify in another document. Where you're citing evidence, this could be in your exhibit, it could be in the other party's exhibit, or it could even be in the other party's statement. where it's in your exhibit, cite the exhibit, for example, in BH1, then the page range, for example, pages 19 to 23, and make in bold. So, for example, you can find this document at BH1, pages 19 to 23, and you're bolding that out to make it stand out for the judge so they know where to find it. Where the evidence you rely on is in the other side's exhibit or statement, refer to those in the same way. So, for example, found in applicant's first statement, paragraph 17 on page 5, or found in applicant's exhibit AB1, page 5, or found in CAFCAS report, paragraph 12 on bundle page E34. Okay, so you're being really, really specific about the location of any evidence that you are relying on for the point that you're making to be considered reliable. Avoid unnecessary commentary and counterattacks in your statement. Keep the commentary relevant. Highlight where any claims made against you are not relevant to what the judge is there to decide. Find a solution. For example, if you're accused of something, even where untrue or if it's trivial, offer a solution as to how whatever it may be couldn't happen in the future. That doesn't mean you have to admit the allegation, just offer a preventative step by way of reassurance to the other side and the judge. Remember, it is often the absence of an evidence of something you would expect to be present that can disprove an allegation. When it comes to making counter allegations, follow this rule of thumb. Are they true? Are they relevant? That's very important. There's no point alleging something if it just has nothing to do with what you're there to decide. And are they necessary? I.e., if you make it, does it make a difference anyway? This is important. If you don't follow the rule of thumb, there are some risks associated, which are you further complicate and inflame the dispute. It can add confusion for the judge when you are simply aiming to give them clarity, not confusion. And it will increase the amount of court time that will be required to determine and make a decision on the issues. If your allegations are not provably true, it's not worth raising them. By raising them, you risk undermining any claims you do make that are true, and you risk not being as credible when you respond to the other side's allegations. Aside from this, follow the same format for collating together your evidence and citing that evidence in the relevant paragraphs of your statement. So let's move on to putting forward solutions. So often claims are made that are born from the other side's anxieties. So rather than stopping at issuing a denial, show how reasonable and solution focused you are by presenting a way to overcome the other side's issue and reassure them and the judge that that's a sensible way to allay their anxiety. So, for example, a claim that might be made is that at handovers of the children, the respondent shouts at me and upsets or scares the children. And your response might be, I deny this allegation. However, to give the applicant reassurance, I suggest that each of us wear a body cam and undertake not to raise our voices at handover. A response like that takes away the risk and means the judge has headspace to focus on another matter that's been raised while demonstrating that you are a solution-focused parent. Right, now we come on to asking for the outcome that you seek. First thing to remember is make whatever outcome requests you have, make them reasonable. If they're outlandish or they are retaliatory or there's any sense of vengeance in them, rethink them and make sure that you are being reasonable. If you I would always advocate for getting a trusted friend or relative who you believe to be particularly balanced in their opinions to take a look through and sanity check any outcome requests that you're planning to make. Make sure you're putting the children's need first in the outcomes that you seek. Demonstrate that you are considering the children's needs, including logistical realities and the impact on the other parent in the outcome you are asking the court for. If the outcome you seek is in response to child welfare issues that are genuine, and that involves restricting contact of parent who may be causing or may be causing genuine harm or the risk of genuine harm, include in your solution a way for those issues to be remedied so that the other parent can play a meaningful role after successful remedy has been achieved. Lastly, don't forget to sign and date at the end of your statement. This slide deck will be uploaded to my website at www.brianhudson.uk. All the other templates that I've mentioned in this slide deck can be found there together with other self-help resources. And if you need professional help with your statement or in court, then you can reach out to me through that website using the contact form. Thank you for listening. All the best.